equivalent to the 436 variable offenses. Only one thing, new things were added in 436, where this is 480 is the 436 equivalent to old section. Provided that such officer quote if he or the things may or shall if such person is indigent or is unable to furnish surety, instead of taking bail bond for such person, discharging on executing bond for appearance and behavior after provided, where the person is unable to give bail bond within a week date of his, from the date of his arrest, it shall be sufficient ground for the officer or the court to presume that he is an indigent person for the purpose of this section. This was newly added. If he is not furnished surety for 6 days, so he can be released without any surety or without any bond. So only small thing was added, the beneficial to the people of available offences. Only one thing was added. This has to be only appreciable. Okay. And coming to the 481, this was a new section was added. But here 481, based on the judgments earlier, Supreme Court also given a judgment, a long pending trial cases accused of in the jails without granting bail. When the Supreme Court has given direction, basing on that, this section was introduced. 481 earlier it is not there. So here they have given chance for half of the sentence and also 1/3 of the sentence. But at the same time, they have restricted this if a person is having the 2 cases. That is totally wrong. Here, if they don't want the police, they wanted to keep a person and theft cases in cases. They will implicate in 4 or 5 cases. Only one case. This applicable and Ashwatthama Atha like this. This applicable. So okay, good. But same time putting a section saying that is only one case. Then only will give you benefit. So if he is not in one case, he will be kept in the jail for till 7 years or 10 years, whatever it may be. This is totally against the marriage. Again is totally against. So this case is not the criteria. Yes, absolutely. That's what I tell you. In the general case, you will add some more cases. So that will add theft cases. This is also theft cases. Next, 482 is our 437. This also there is no benefit given and provided here. Something was added. Only one thing was added. Earlier judicial mistake, even though it is not there in the bail provision. So simply because a petition filed for test identification for it, the bail cannot be granted like that. There is no such provision. The Supreme Court also given a judgment. In spite of giving these Supreme Court judgments, they generally, as a routine manner, the judges are dismissing the bail application, saying that PA parade is pending. But here, in this, that one provision was added. This you have to see the good and bad also. This one provision was added where he has given a provision saying that simply because the PA parade is pending, bail cannot be refused. So he provided also that the mere fact that accused person may be required for PA identification by witness during the investigation shall not be sufficient ground for refusing to grant bail. This was added. This is, you have to appreciate this. This is correct. But in spite of this, long back only Supreme Court has given judgment, but nobody is following the judgment. Simply they will dismiss you. Police will file a counter saying, sir, we are going to conduct. Even without requisition also, they will mechanically file a memo saying that we are going to file requisition. Basing on that, immediately they will dismiss. But this provision also there, added. And apart from that, class 6 to the 482, that is 437, also they are added. If any case is tried by the magistrate, the trial of the person accused of any non-bailable offence is not concluded within a period of 60 days from the first day fixed for taking evidence, and in case such person shall, if he is in custody during the whole said period, be released on bail to the satisfaction of the magistrate. This is also due provision. But appreciate this long pending cases and the trial is started. Even in the magistrate courts, one witness will be examined 6 months or 3 months. In a trial cases, jail accused will come to court for 2-3 years. So here they are restricted. If a 6 months court is not conducting trial, police are failed to produce witnesses, conduct is the trial is not conducted, accused is entitled for bail. That is added, section 6. And also the clause also 7 also. Even 7 also, when before pronouncing judgment, court found that there is a sufficient ground. After recording some evidence if court found that the evidence may not give any conviction, the court can grant bail. The provision also added, new provision to the 437, that is 482 law. And the clauses were added, they are beneficial to the accused. Some are only. And 484 is 438 CRBC. This there is no drastic change, but one thing. Sorry. The notice has to be given to the persons 64 and 66 and 70. There's rape cases and gang rape. The victim has to be given notice and other things. That is natural justice. Okay. But as far as the 439, that is the 485, is a new act equivalent to the 439 or regular bails to the session, where other things are same, but one section, the subsection was added. Here, he provided further that the High Court or Court of Session shall, before granting bail to a person who is accused of offence triable under section 64 and 70 and Bharatiya Nyaya Sanhita, give notice of application for bail to the public prosecutor within period of 15 days from the date of receipt of notice. So, unfettered powers were given to the public prosecutor. Not only that, if anybody implicates any person under the rape case, he has to kept in the jail for minimum period of 15 to 20 days. If it is a no case also, for hearing they are giving a time of 15 days. You have to give a notice for minimum 15 days, hearing and notice. So if there is a case of nothing, any false complaint is filed by anybody saying that I have raped by so and so, they will arrest and keep it if they wanted to keep. Any minister can be arrested. Here, how they are incorporating, they would have known. Even they will also suffer this. If anybody wanted to implicate, send any person, some people will have a satisfaction that I have to send you for jail for 2 days. Here you can say, by using the police services, you can send anybody to jail for minimum 15 days. That's minimum. It will take 15 days notice for hearing. 15 days or 5 days means minimum 20 days in a rape cases. This is also not correct. Prima facie case is there or not also, you have to stay minimum for 15-20 days. So this provision is also totally against the fundamental rights and this has to be changed. This time, giving notice to the victim is different. Notice has to be given to the victim. But at the same time, giving a time of 15 days to the BP to argue, this is totally wrong. This is totally wrong. And coming to the last section, I will complete. Section 532. 532 of the Bharatiya Nyaya Suraksha Sangh. A trial or proceedings to be held in electronic media. All trials, inquiries and proceedings under this code, including summons, holding inquiry, examining complaint, witness, trial court, court of session, warrant cases and session cases and evidence in high court and all the trials before courts. So here, using the electronic media is correct. But in all cases, it gives, in no case, if any case, contested case, in all cases, accused will be convicted. A witness is giving a free chance to sit in some place. They will keep up all the evidence with themselves and they will give answers as per their choice. Who will monitor? Who will monitor? How can they give evidence? There must be some restriction. Depending on the cases, court can, if it is earlier, there is a provision. The Supreme Court, basing on the Dr. Prafulla's judgment, Supreme Court has given a direction that 2010 amendment was made, giving a right to the court to record evidence in the summons cases and in warrant cases, court feels. But here, total any case, any witness, If any witness sitting in the house gives evidence, naturally there will be an availability of so many things. They will take assistance of so many persons, and documents also keep all the documents with them, and they will give evidence by reading the documents. So every case there is no question of acquittal. If this is allowed, in every case you will not get any acquittal. There will not be trial. There is no trial. There is a possibility.
No fair trial.
Fair trial. There is no fair trial. Otherwise, here it has to be added. Here, even Telangana, after the COVID-19, the government has formulated the video conference rules. At least they would have been provided here as per the guidelines or the video conference rules of the state. There is nothing provision. They need not follow the, as per this 532, they need not follow any guidelines. Directly they can, everybody can sit in the house and easily can give evidence by playing and doing, creating all this, taking support from others. You will not get any acquittal. Certainly this will be misused. In particular case, if anything is permitted or witness is not in the position to come to court, or if any problem is there, if any petition is filed, the court is satisfied and putting by following the procedure prescribed under the video conferencing rules provided by the government of Telangana. That was already changed. But here, by seeing this, there is no provision, there is no nothing like that in 532 by following the rules provided by the state government or central government. Nothing. Simply all persons will be examined. Video conference will be taken. You have to force to accept this section. So no justice will be done with this itself. It is 532, every case, everywhere you lose the case. Question of winning case does not arise. So everybody will sit in the house, they will prepare the evidence and they will give according to that. So you will not, nobody will get justice with this 532, and as in the stated earlier also with regard to the section 107. 107 and 532 are the dangerous provisions for entire Indians, not to the only to the particular persons. Everybody will face some time. This also will come to some time. If anybody files any case, where somebody goes and tries to say that this advocate has done something and he has taken my money, he has purchased the car, he will go and file complaint, the car will be seized under 107. And like this, 532, everybody will go and give evidence by keeping the fabricated evidence within his purview. This section, giving unfettered powers to recording statements and witness, this also create a confusion in this. This, and I will conclude, seniors are there and just only some sections are covered. There will come other sections. And with this, the entire act has to be rethink and this has to be changed. Otherwise, they are not given any opportunity. Government mechanically doing and follows, telling and the bills also passed. Nobody is thinking. They are thinking about winning in the elections. When all have to come and all have to face the consequences. Nobody, no particular leader is coming and telling these laws are wrong. They are thinking the laws are only meant for the public. But this will also come to them. Now people are going to jail. These sections, when opposition will use this section, everybody will face the consequences. Everybody will face the music of these provisions. They have to oppose. Even media also not coming forward. As on today, I have not seen any media also discussing with regard to the implications of the provisions they are going to amend. This affects everybody. Even media has to take this initiative. Media is not taking, and our Bar Council is also not taking. Our Bar Council of India also not taking any care. Nobody is taking care of these amendments. As on today, yesterday, Police Satyanarayana, when we were sitting, we were asking our chairman, asking, sir, why you are not conducting this? He is telling, there is no direction. Bar Council is not telling anything to conduct meeting. Is it necessary for Bar Council of India to direct anybody to discuss? Not. It is affecting all. Here, Bar Council of Telangana is also every right. And also is the responsibility of the Bar Council of Telangana. But my chairman yesterday is telling, as he is not having a direction from DCI, he is not conducting here. So like this, everybody is avoiding, but everybody will be suffered in future. You have to face the music. So So until unless the changes have to be taken place, otherwise everybody will be suffered. This has to be changed. And I again appreciate the ILU for conducting such programs, sir. They have conducted this so that at least some people will know, then they will spread what is there. Like that it can be spread and see that this has to be changed. Thank you.